Hello and welcome to the latest legal update for the solicitors group TSGLegalTV channel. My name is Paul Butt and today I'll be discussing adverse possession and residential conveyancing. I'm sure we're quite used to dealing with situations, whether we're buying or selling residential property, where the property owner, the seller, has acquired, taken over an extra piece of land in addition to that's strictly included in their title. Maybe they've seen a piece of land at the bottom of the garden or the side of the garden that no one seems to claim ownership to, and gradually it's been incorporated into their property. Only becomes an issue really when the property comes to be sold and the buyer notices that the description of the land as on the registered title compares the title plan with the actual land itself and sees this extra bit is there. What we need to do as conveyancers in that situation to see whether it is possible for the seller to claim ownership of the land, possible for the buyer to get themselves registered as proprietor of that land, using of course the principles of adverse possession. Now, I'm sure we're all aware that the basic rule is if you occupy somebody else's land for 12 years, then the land is yours. And that's what we're looking at in this situation. The particular problem arises that I want to mention because of the impact of the Land Registration Act of 2002. Originally, the law relating to adverse possession was the same whether the land that you were squatting on, the land that you were acquiring, was registered or unregistered. 12 years, the land was yours. If it was registered land, you have to make an application to Land Registry to get yourself registered, but simply proving the 12 years possession would be sufficient. Unfortunately, since the 2002 Land Registration Act, the position has become somewhat more complicated. When the Law Commission were looking into registered land and making recommendations for a new Land Registration Act, they were very concerned about the impact of the rules of adverse possession on registered land. The idea of the Act was that we should have a comprehensive register of who owned every single piece of land in England and Wales. Because that couldn't be comprehensive if the register said one thing, said that X was the owner, but the law of adverse possession said no, the squatter Y was the owner. You didn't have a comprehensive register. So the law of adverse possession would have to be changed to deal with that. Equally, there were very serious Human Rights Act worries. Human Rights Act, very familiar to Daily Mail readers, no doubt. One of its provisions is that no one should be deprived of their possessions except in the public interest. And that, of course, is precisely what the law of adverse possession does. It deprives a property owner of their ownership of the land, simply because they've not been in occupation for 12 years. Was that in breach of their human rights? And remember, of course, that where adverse possession works, there is no compensation payable to the property owner. They lose it completely, no compensation. So basically, the 2002 Act disapplied the Limitation Act to registered land. It set up another system whereby ownership of registered land could be acquired, but not quite as straightforward as in the past. You've probably seen some suggestions of registered land now being squatter-proof, and certainly a well-advised registered proprietor can prevent a squatter getting ownership of the land very simply. Very much more difficult, therefore, for a squatter to prove ownership of registered land, and that's the important bit in a conveyancing transaction. So what we've got are now different sets of rules for registered land and unregistered land. So when you're dealing with this person squatting on an extra bit of land they've incorporated into the garden, the initial thing is going to have to be to do an index map search to find out whether the land is registered or not. If it's unregistered land, 12 years adverse possession, the land is the squatter's. A buyer can get a stat dec from the seller to that effect and then get themselves registered at Land Registry with possessory title. If it's registered land that is being squatted on, then, as I say, it becomes more complicated. The initial thing to work out is whether the squatter had been there for 12 years prior to October 2003. That's when the 2002 Land Registration Act came into force. The Act, as I said, disapplies the Limitation Act, disapplies the basic adverse possession rules to registered land, but only for the future. It's not retrospective. Any squatter who'd clocked up 12 years adverse possession as at the 13th of October 2003, they already owned the property as at the 13th of October. And in accordance with the Human Rights Act, you can't take their rights away from them. You can't deprive them of their property, albeit they'd only got it by depriving somebody else. So there were transitional provisions written into the Act that if somebody had clocked up 12 years adverse possession as at the 13th of October, then the old rules continue. The old rules continue indefinitely as long as the squatter remains in possession. Under the old rules, 12 years, it belongs to the squatter, and they can get themselves registered. So in effect, we now have three systems: the unregistered land system, the old rules with regard to registered land if you can prove 12 years as at the 13th of October. In both of those cases, squatter will get registered if they can prove 12 years adverse possession. The third system, the new system under the 2002 Act, is where it's registered land and 12 years adverse possession could not be established by the 13th of October. Then the new rules apply. Under the new rules, yes, if you've been in adverse possession, you can make an application to get registered. And indeed, you only need to prove 10 years adverse possession before you can make the application. But, although it sounds like it's going to be easier to get registration as a squatter, 10 years rather than 12, but if the registered proprietor objects, and why wouldn't they, then the squatter is only going to be able to be registered if the squatter can prove one of three additional conditions. No objection, the squatter will get registered. Registered proprietor given up their rights. If there is an objection, squatter will not be registered just on the basis of adverse possession. They'll have to prove one of three additional conditions. Additional conditions that, two of which at least, will very, very rarely apply. So this is why it's becoming harder to get possessory title, a possession title, to registered land. Three conditions are, firstly, that the squatter ought to be registered because of an equity of estoppel, proprietary estoppel. And that's only going to apply when the registered proprietor, the real owner of the land, has made representations to the squatter, yes, it's okay, the land is yours, you can stay on the property, and the squatter has acted on that to his detriment. So maybe a squatter starts building property on the land, proprietor knows of this, and makes it clear he's not going to object. That would be an estoppel situation. That isn't that common in adverse possession cases. In adverse possession cases, the proprietor often doesn't know the squatter is there. That's the first situation. The squatter can prove that, they will get registered. The second situation, the second of the three conditions, is where the squatter ought to be registered for some other reason. Some other reason in addition to, over and above, adverse possession. And according to the Law Commission, who devised these rules, that's meant to deal with what we might call informal land transactions. Situations where there's been a sale, a disposition of land, but the formalities have not been fully complied with. I've certainly come across it with farmers. In my experience, farmers don't like using lawyers, and when they do use lawyers, they don't like paying their bills. But certainly I've come across situations where two farmers have informally sold a field, an outlying field that one farmer had no use for, agreed with the neighbour that the neighbour would buy it for a couple of £1,000s. They shake hand over the field gate, money is handed over, a receipt delivered for that land. Not legally valid in any way, shape or form, no deed, no written agreement or anything. So no legal ownership has passed. But obviously it was intended there should be a transaction. if you can prove something like that, then that will be another reason, in addition to simply being in possession, whereby the squatter would be entitled to be registered. But neither of those situations are your classic residential squatter who takes over an extra bit of land that's attached to the garden and incorporated in the garden. The third condition, that is the one that will apply most often, is where the land that's being squatted on is adjoining the squatter's own property, and there's a dispute as to the boundary. The squatter genuinely believes, and has believed throughout the 10 years, that the land is really his. So he genuinely thinks it's his land. And that not uncommonly happens in new housing estates, shall we say, where you've got the title plans all showing nice little neat plots of land that the developer's going to sell off, and the fences aren't put in the right place. Technically, anybody looking at the land will assume that the boundary is where the fence is. But in reality, the boundary is where the title plan says it is, which is somewhere different. Obviously, in that situation, this reasonable belief that the land is yours would be relevant. And once you've been there for 10 years, then you're entitled to get registered with regard to that piece of land. But again, it's not going to apply to a situation that we commonly come across in residential conveyancing, where we know very well the land isn't ours. We're not confused as to where the boundary is, but we just see this bit of land over the other side of our garden fence, garden hedge, which no one seems to lay claim to, and we incorporate it into our garden. There's no suggestion that we reasonably think it's ours because the boundary's in the wrong place, or the boundary fence is in the wrong place. So in the classic situation that we commonly come across in residential conveyancing, it's likely that none of those three conditions will apply. There's no estoppel, there's no informal land transaction, and there's no genuine belief that the land is ours. We know very well the person doing the squatting, the seller, knows very well it's not his, they're just trying it on. In that situation, we're going to have to be getting used to advising the buyer that even though they've been there for 12 years, 15 years, whatever it is, anything other than 12 years before 2003, the likelihood is if they make an application that they're not going to become the owner of that land. The likelihood is that the proprietor will object if an application is made, and they will not be registered. And presumably once you've alerted the proprietor that you're occupying his, her or its land, then you're going to get evicted from it. Maybe some argument, some excuse for letting sleeping dogs lie and not making an application. At least you're still enjoying the land. The only possible exception to that might be in the situation where the registered proprietor is no longer at the address for service that's shown on the register. If they're no longer at the address for service, then they're not going to get the notice from Land Registry when you apply to get registered, and therefore not going to be able to object. Another reason for making sure people keep their addresses for service up to date. But as I say, there are big issues arising with regard to adverse possession. We've got to realise, we've got to advise buyer clients that there are these three different situations. We need to be alive to the checking out which of the three apply, to give advice to our buyer and indeed our buyer's lender as to whether or not they are going to become registered as proprietors of that land. Well, that's all I want to say about the topic at the moment. On behalf of myself and the Solicitors Group, thank you very much for listening to this legal update. Keep an eye out for further updates from TSG Legal TV, and we look forward to seeing you again soon. Thank you.